Hi, I'm Jacob Stein, and I'm a partner in Aliant's Los Angeles office, and I head Aliant's private client practice. I am best known for asset protection planning, and in these short videos, we answer some very common questions about asset protection planning. And one question that comes up very often, and I think it's a really interesting question, is about hiding assets. Is hiding assets an effective approach to asset protection planning? And I think a lot of people do associate hiding assets with asset protection planning, right? Because if creditors cannot find your assets, how can they get them? So let's talk about hiding assets from a technical standpoint, right? But also let's talk about it from a practical standpoint. So from a technical standpoint, does the hiding of assets work? Well, it really depends. It depends on how aggressive and diligent the plaintiff will be in the pursuit of your assets. Right? Some plaintiffs and creditors will take a look at publicly available information, trying to find your assets. And if they cannot find your assets, they may decide that there are no assets for them to pursue. And then perhaps they walk away, or they're more willing to settle with you. But other plaintiffs and creditors will be very diligent in their research, right? They will not only perhaps hire private investigators to find your bank accounts, which is totally possible, but they will, once they obtain a judgment, pull the debtor into what's known as a debtor's examination. And this is an examination of the debtor that is conducted in front of a judge or a magistrate, where the creditor gets to ask any question they want to related to the discovery of the debtor's assets. And the debtor has to answer those questions under penalty of perjury. So imagine that the asset protection planning you engaged in was, selling everything that you have, then going to Home Depot, getting yourself a shovel, driving out to the desert, digging a hole, right? Burying the cash. Awesome, right? Worked for centuries for so many people. But what if in the debtor's exam, one of the questions that the creditor will ask will be, hey, have you been to Home Depot recently? So now for that strategy to work, the debtor must be willing to lie under penalty of perjury. Now, I'm not going to try to guess how many people lie under penalty of perjury, at least in the debtor's exam, trying to keep what they have. I'm sure it's a very significant percentage. But we as lawyers certainly do not want to place our clients in that position, and we do not want to encourage our clients to lie under penalty of perjury, because we all remember what happened to Martha Stewart, right, as a result of perjuring herself. So when we are engaging in asset protection planning on behalf of our clients, we will always assume that the plaintiff will discover the assets, right? So that's the technical analysis. They will know what the assets are, and it still has to work. So we do not often rely, at least in a technical sense, on hiding of assets. So what is this distinction between technical and practical? Well, from a practical standpoint, again, there are those plaintiffs and creditors who are not going to dig deep, who will not be able to find our clients' assets because they just kind of look around at what's available sort of easily and inexpensively, and they stop there. So if our client does have assets that are titled in some generically named irrevocable trust in the name of their kids hidden away, maybe the plaintiff will never bring that lawsuit in the first place. And that's a huge win. So I'm not against hiding assets. I think it is effective often. It does make it difficult for plaintiffs and creditors. It does discourage them, but it's usually not something we can rely upon. I'm Jacob Stein, and thank you for listening.